Okay, Robert, now again, let's get to the next one, but hold on. I saw flattery. Flattery, oh, a lot of taking the high road. Disney defenders seem like they are very unlikely that. Okay.
That's
and
true.
David, you're the best person. If everyone were like you, the world would be utopia. No, the world would be hyperactive and very annoying. I can appreciate too much Viva would be very annoying for everyone around you. And I have my foibles as well. But Robert, okay, Marjorie Taylor Greene. I know what I initially thought of her. I'm human. All I hear is that she's extremist. She says terribly stupid things. She retweets violent messages. I've seen some of her tweets, not tweets I would ever make myself, but do I think that they are evil incarnate? I'm not so sure. I know what I thought of her to begin with. I saw her testify on Friday. I now know what I think of her after having gotten to know her legally. But I don't know what the heck is going on here. This is a very complicated thing. What the proceedings that she's facing, the administrative proceedings to try to prevent her from being able to run again. She filed a civil temporary restraining order to basically to suspend the proceedings, the administrative proceedings against her. Matt Gaetz got dismissed from these proceedings on an 1872 exemption amnesty. Robert, I know enough to know I know nothing of what the heck is going on. I just know the questions to ask. What proceedings were filed against Marjorie Taylor Greene to have her booted from the ballot or precluded from running for office again?
Yeah, well, it's all Mark Elias's strategy to use the old Confederacy ban from Section 3 of the 14th Amendment to go after their strongest critics. And their critics are, Senator Johnson in Wisconsin, Congressman Cawthorn in North Carolina, Congressman Gaetz in Florida, Congresswoman Marjorie Taylor Greene in Georgia, and Paul Gosar and a few others in Arizona. So it went to court in North Carolina with Madison Cawthorn, and the federal judge said that it didn't apply and it could not be used as grounds to remove him from the ballot.
It being Section 3 of the 14th Amendment. And now I had Nate on Friday with Eric Huntley. They had a disagreement on the essence or application of that Section 3 of the 14th Amendment. I think Nate is less right than Eric in the interpretation. But what was the intended application of Section 3 of the 14th Amendment in terms of barring people from running for office again?
The real answer is radical Republicans wanted to keep Southern Democrats out of Congress after the Civil War. That's the real answer. So, and there's serious questions about the 13th and 14th and 15th Amendment because the states that passed them were states that most people weren't allowed to vote in them. So it's like, did that really? That's why the U.S. Supreme Court, when it came time to visit the 16th Amendment, was like, we're not getting near this because then the 13th, the 14th, and the 15th would have some serious issues. That's why I said the greatest power is who gets to determine what's in the Constitution. And one of the great loopholes of the Constitution is the archivist of the United States could declare himself king legally and disband everybody and put the army under his complete control and end all elections because he could just say the Constitution's been amended to so declare. And according to the U.S. Supreme Court, nobody's allowed to challenge the archivist. I find that a little insane, but that is literally, it's one of those abstract loopholes that we don't think would ever happen in real life, but actually could happen legally. So the same dynamic, what the 14th Amendment Section 3 said was that if someone, while under oath to either state or federal office, had supported an insurrection, a rebellion, or given aid or comfort to the enemy, then they could be denied their position in Congress as long as two other conditions. Congress could, by 2/3 vote, overrule that. And the 14th Amendment said Congress could pass legislation to interpret and enforce this, which also relates to another constitutional provision that says when it comes to members of Congress, only Congress itself can determine whether they're qualified to be there. So these are the overlapping provisions. In 1872, we got past the radical Republicans kind of lost power as part of what happened. And so they passed an Amnesty Act that said, really the only implementing legislation ever passed by Congress on this, that said, okay, everybody that was disqualified by that's now qualified. And then there was a second Amnesty Act passed in 1898. They reinvigorated this in 1918 to go after the socialist Congressman Victor Berger from Milwaukee, who was against World War I. And on the grounds that he was giving aid and comfort to the enemy. They could only do that because there had been a declaration of war, and thus certain nations had been listed as an enemy. And he had said we shouldn't go to war, in that case with Germany in World War I. Big German population, of course, in Milwaukee. German socialists dominated Milwaukee for a good period of time after the beginning of the 1900s. They reinstate, and Congress said, yeah, we can reinvigorate this, and the Amnesty Act doesn't apply because that's only retrospective, not prospective. It goes to the first court system in North Carolina. Cawthorn says, no, the 1872 Act, because he's recognizing the real history. This was meant to deal with Confederates. We decided not to do it anymore in 1872. The law requires Congress's implementation for its interpretation and enforcement by the 14th Amendment's own explicit terms. And it explicitly gives Congress the right to change the rules, which it has done by its own explicit terms. And the Constitution says only members of Congress can determine the qualifications of members of Congress. So that's Cawthorn's judgment. It goes to Totenberg in Georgia with Marjorie Taylor Greene. Well, I'll skip her. It goes to Arizona next. Arizona, they challenge Gosar and two other Arizona congressmen. Same grounds. They say these are insurrectionists. They are not constitutionally qualified to vote. The Arizona State Court does a very deliberate decision, goes through this whole history and says, no, this provision does not apply. And at a minimum, there's no private right cause of action. That Congress has to pass laws defining this and interpreting this, and Congress alone can enforce it unless it says otherwise, based on the constitutional structure for congressional membership. Then it goes to, so that court dismisses it, says all these congressmen can run. Then it goes, I'm not sure what happened with Gates. My understanding is, I don't know if it's reached the court process.
I thought Gates was dismissed as well under the 1872.
It probably was. Then for Marjorie Taylor Greene, they have a different process. You don't initiate the process in the courts. It's kind of like North Carolina. You initiate it through an administrative proceeding. Any Joe Schmo can file a challenge to whether somebody's qualified get themselves discovery in a hearing in Georgia.
I need to stop you just for one thing that goes back all the way. And by the way, whoever just said the chat of what the disagreement was, you're right. It was on the right to secede. We'll get to that after. But Robert, the 14th Amendment, section paragraph 3, it says anyone who participated in an insurrection or rebellion. Question number 1. Who determines whether or not there was an insurrection or rebellion? Does it have to be an actual declaration of insurrection or rebellion?
That's it. That's why the Arizona court said, if you look at the entire 14th Amendment and you look at Article 1, Section 5, and you look at the various provisions of the Constitution in terms of application and interpretation and enforcement, particularly as to congressional membership, that this is something Congress has to define. Congress has to Congress probably has to enforce unless it chooses to allow private causes of action. There's legislation pending to try to do this. It will never get through the Senate, so it probably won't go anywhere. But they never have. And in fact, again, this was really a historical relic that was meant to screw over the ex-Confederates and really all Southern Democrats, so that the radical Republicans could have carte blanche control, more than 2/3 control. Once they no longer had that control, the 1872 Amnesty Act was meant to put an end to it. We sadly reinvigorated it when we don't like war protests, which is ugly history, but that's the nature of it. Briefly in 1918, we had a lot of bad ideas rolling around in 1918. Ultimately, the protest against the war vindicated and validated Victor Berger and others. And so we never reinvigorated it again. And this is the first time leave it to Mark Elias to make up an interpretation and suddenly say this should somehow stop my opponents from being allowed on the ballot. Mark Elias, who if John Durham had any ethics, would have already criminally prosecuted him for his role in Spygate and Russiagate, as is being detailed in the Sussman case that's about to go to trial in more briefings this week. But watch, he won't. Because he's there to cover up for the system, not really expose it. Just pick a few fall guys and then move on to make it look like you did something, but don't actually do anything. That's what Durham's really good at. But maybe I'll be proven wrong. But that's really what it is. And so because you could look at, there are criminal statutes that define insurrection and sedition and rebellion. And so but they were never meant to, and they're not explicitly interpreting this statute. This constitutional provision. And then really the 1872 Amnesty Act was meant to put an end to it. And we've only occasionally reinvigorated it for bad purposes when we want to target political dissidents. And it's not a coincidence they're targeting Cawthorn, one of the most effective populists in the House. Marjorie Taylor Greene, one of the most effective populists in the House. Matt Gaetz, one of the most effective populists in the House. Paul Gosar, one of the most effective populists in the House. All four, by the way, voting against sanctions on Russia, along with Thomas Massie. And they're using statements about January 6th because they need to redefine the election fortification that took place as illicit insurrection and fraud claims, that it was inherently bad to second guess that election, like it's inherently bad to second guess our current war efforts. These people sit at the nexus of both, and they're just using this bogus proceeding, in my view. But the bad luck for Marjorie Taylor Greene is she drew Judge Totenberg, and that meant zero chance she was going to win in court.
The judge Totenberg that's in the court case, not on the administrative hearing case, correct?
Right. So
okay.
What happened is they initiate, in Georgia, anybody can initiate a cause challenge for qualifications in the administrative process. She sued in federal court, Marjorie Taylor Greene, as Cawthorn had in North Carolina, and said, look, this process violates my First Amendment rights, it violates the Constitution's explicit and exclusive delegation to Congress for enforcement on constitutional qualification questions. It says that only Congress can determine whether its members qualify under the Constitution. For some time, and one of the cases she only cited two. One of them was mine, which I'm still ticked about. So I brought a suit on behalf of this little young socialist in California. And she had been denied the ballot summarily by Kamala Harris as Attorney General. And because they didn't like her. They didn't like this little lefty being on the ballot. She was sort of young, charismatic, etc. So I filed suit on the grounds that whether or not she's constitutionally qualified under the 25th Amendment is a presidential question. And that, in fact, you can argue the 25th Amendment anticipates someone being elected to the presidency who doesn't meet the qualifications yet. The vice president would then hold the office until the president was qualified, and it'd be up to Congress to make a determination on that issue. There's been a lot of bad rulings from the federal courts for the last 60 years on ballot access issues. They basically will want the state to monopolize the ballot, control the ballot. And all of it was done for your, the secret ballot, all of that was done for your benefit. No, it wasn't. It was done to screw over populist and labor movements in the United States because a lot of their populations couldn't read in English. And so what happens when you require they read in English in order to vote effectively? What happened is people used to be given ballots as they went in from people they trusted in their local neighborhood and community. And then they'd put that ballot in. The secret ballot said, well, we can't allow that. We need the state to monopolize the ballot. Now, we would never use it to disqualify people we don't like, right? But that's all they've done for over a century, is use it to try to keep people off the ballot that are popular. You don't need to keep them, and it's all done by the lie. Then Judge Gorsuch helped perpetuate this lie when he was on the 10th Circuit, because he allowed states to say a presidential candidate could be struck by the state government, and you, the voter, couldn't even have the option of voting for them based on the state's determination as to their presidential constitutional qualifications. My case went up to the 9th Circuit. 9th Circuit followed Gorsuch and said that, in fact, one of the judges said, well, what if the people put Bugs Bunny on the ballot? And my response was, a lot of people would prefer Bugs Bunny to a lot of the people we have been electing lately. So but I went back and forth at it with that judge. But they like the state having this power to keep out the rabble, because it's noteworthy. There has been a context where presidential cause challenges were brought, and the court said, no, that's not the business of the state. The state government has no right to do that. No court has the right to do that. That was when people challenged whether John McCain, born in Panama, Barack Obama, allegedly born outside of the United States, whether they met the definition of a natural born citizen to meet the ballot. All of a sudden, then the court said, oh, no, we can't get into that. No, they have to be allowed on the ballot. Yes, indeed. It shows you how corrupt and political and partisan these courts are. But as to Congress, as the Arizona court pointed out, the issues of, I had my 25th Amendment interpretation, which was novel at the time, still is, they didn't even address it, that lazy partisan 9th Circuit decision. But there's no question that congressional qualifications are determined by Congress explicitly by the Constitution. So that's why, and Totenberg just ignores this, pretends these two decisions about the presidential candidate govern. They don't. There's total difference between those two because of the issue related to Congress having exclusive control over qualifications written right in the Constitution. Totenberg ignores it and says the Georgia administrative process can go forward. Now, Marjorie Taylor Greene will ultimately win that because the ALJ assigned the case. What happens is they have a hearing. Anybody watch that hearing can see what an embarrassment it was. Apparently, 1776 is now insurrection. You can't use the reference 1770. You're an insurrectionist.
Everything is code except when Maxine Waters says to get in the faces of politicians and harass them. But Robert, hold on a second. Just make sure I understand. Marjorie Taylor Greene failed on her 1872 amnesty, despite the fact that Matt Gaetz succeeded on it.
Or Madison Cawthorn did.
Madison Cawthorn, sorry. If you can, one sentence, remind me how that happened again.
So, I mean, what happened is in 1872, Congress finally enacts the power they had under the 14th Amendment and says the disqualification provisions will no longer apply, period. That was explicit power. The Totenberg decides to pretend that was an amendment of the Constitution, that was, she has one line that says, the argument is that this is simply enforcing a provision that Congress has, but that's just rhetorical. Well, no, it's a totally different legal argument. It's like, when language is different and the structure of an argument is different, it's a different argument. And she pretends that argument doesn't exist. And again, why? I have no doubt that if this was Senator Ralph Warnock, Totenberg would have found that this was being applied illicitly. Totenberg, if people recognize the name, related to the NPR Totenberg, I mean, one of the most activist liberal judges in the country. It's the problem in Atlanta is, if you're in Georgia, it's a problem that needs to be systematically solved. It's like the District of Columbia. You have to go to the political capital, and the political capital is filled with your adversaries. And this is true even of the federal court process. So, but definitely true in the state court process. So she says the 1872 amnesty doesn't apply. She says that the Congress doesn't get to exclusively define qualifications. She says there's basically she applies all of the ballot access rules she waters that down to its lowest possible standard to say if there's almost any rational basis for the rule, it can be done. So she green lights the continuation of this harassment of Marjorie Taylor Greene in this cause challenge. However, it's likely to all be mooted because the administrative law judge, he doesn't make the final ruling. He just makes recommendations, but he's likely to say that he doesn't meet the legal definition. The decision has to be made by the Secretary of State, Ratberger.
Who you have called, by the way, if I'm tearing, I have a tickle in my throat. I can't stop it. I inhaled something that I shouldn't have. And my nose is red because I got some sun. But so the administrative judge, they call them whatever. He's an administrative
ALJ.
Judge. He renders a recommendation that he submits to Raffensperger, who makes the final determination.
Yeah, his real name is Raffensperger. I call him Ratberger for short because that's what he is. But I don't think he would be dumb enough to exclude Marjorie Taylor Greene from the ballot. I think he's running for re-election. I haven't double checked that. He should lose anyway. But I mean, that would and then that decision can be challenged in a state court in Atlanta. She is, of course, I believe she's appealing the denial of the temporary injunctive relief to the 11th Circuit. Ultimately, there's no grounds for her to be disqualified from the ballot, period. I assume the ALJ will say so. I assume the Secretary of State will determine it so, and that should end it. But the fact she has to go through any of this is nuts, and it's because of a misapplication and misinterpretation and political weaponization of the law in a way that's ahistorical or counter-historical and not consistent to, but contrary to the explicit and express language of the Constitution.
Well, some people said there might be a net positive for Marjorie Taylor Greene, because I'll tell you this, I'm pretty open-minded. I didn't watch the Tim Pool episode, not just because I had never seen it. She came off much more reasonable in her examination than the media portrays her. And I think that's going to be a net positive for Marjorie Taylor Greene. A lot of people are going to say also the system is almost irreparably screwed if this is what they're trying to do to get people off the ballot from the democratic process. but it's look, it was a good hearing to watch. I don't know if it's going to continue next week, but bottom line, that judge, the administrative judge, does not render any decision. He just issues a recommendation to Raffensperger, who's going to issue the final order, which itself can be challenged.
Yes, I mean, and it's I mean, what the administrative law judge should say is that he doesn't have the authority or power, nor does the state of Georgia have the authority or power to do this, and he should follow the rulings in both the federal court in North Carolina and the state court in Arizona. That's what he should say. We'll see if a lot of your ALJs are not the most inspiring people in the world.
Yeah, but you know, this guy looks like he's getting it. When I was looking at his face when the Marjorie Taylor Greene's attorney was making closing arguments. The judge gets it. I mean, the judge obviously gets it. To anybody with half a brain, and I say this totally politically unbiased, it's bullshit. I mean, it's actual straight up bullshit. You don't need to fortify elections when you can just keep people off the ballot. To say that she should be kept off the ballot for aiding or providing comfort to rebellion, no one was charged with insurrection, Robert. No one was charged with rebellion, and they're going to say that what she said, which was, we want to do it peacefully. But bear in mind, it was from 2 years earlier. Their central.
And the reality is, we've only had one legally defined insurrection in American history, and it was the Civil War, right? And I mean, that's what that meant. I mean, if you took an oath to the Confederacy after you had been taken an oath to the United States Constitution, that's who this was meant to apply to, not to anybody else. And then 1872, we gave a full amnesty to say we're no longer even going to apply it to them. So that should have been the end of it. It's ludicrous. It was misapplied in the case of Congressman Berger. I mean, Eugene V. Debs went to prison for his dissident beliefs. People forget this kind of thing because we whitewash it in our classrooms. You know, when you're doing your history class, you either get the crazy woke leftist nonsense, America's an evil empire, killed all the Indians, or you get sort of a mythical, in some of the mythical conservative ones, they leave out, you know, the things like, oh, we lock people up for their war protest, and we used to forcibly sterilize people and treat them like human guinea pigs, as Barack Hussein Obama was bragging about this past week. He goes, we got to experiment on 1 billion people. Wasn't that great?